Now, referring again to Plaintiff's Exhibit number 1 for identification, it states here on page 1 that SAVE, which is the short name of Save More Corporation, SAVE shall incur no liability for or on behalf of Parnell for any manufacturing, sales, or distribution expense, unless first approved in writing by Parnell. Did you approve in writing the expense incurred by Save More Corporation for legal expenses payable to Mr. Kranz? Defendant's counsel objected to as being immaterial at this time. Will you state specifically what legal expenses and the dates incurred thereon? Plaintiff's counsel, referring to plaintiff's bill of particulars submitted by plaintiff on page 2 thereof, there is an item which states, preparation of assignment of undivided interest to Irving Roman and Floyd Parnell, patent application, serial numbers 261549 and 113264, $25. Referring to this particular item, I will ask you whether you authorized in writing that Save More Corporation make this expenditure of $25. What date was this? June 15th, 1954. I might point out that the date of the agreement, Plaintiff's Exhibit number 1 for identification, is the 10th day of June, 1954. Defendant's counsel, I may point out to counsel that in that part of the bill of particulars, those services, according to the bill of particulars, were rendered to Melvin Stone, not to the corporation. Plaintiff's counsel, that is correct. And the original question was whether he had approved in writing. Defendant's counsel, no, you did not ask that. You asked whether he had approved in writing that the corporation make that expenditure. Plaintiff's counsel, that's right. Defendant's counsel, the corporation had nothing to do with that expenditure, and the bill of particulars sets out that it was Melvin Stone's obligation. Plaintiff's counsel, you are correct in that observation, counsel. That is very true. Coming down to the 31st day of October 1954 of this same bill of particulars, we come to the item also on page 2, preparation of trademark application on Save More, case number 902, $50, being the cost of drawing, print, $10, filing fee, $25, and time spent on the other matters listed, $100, or a total of $185. This item was for services rendered to the Save More Corporation on the 31st day of October 1954. Referring to that item, I ask you whether you approved in writing the expenditure of the services which were rendered to Mr. Kranz. To the best of my knowledge, no. Do you know that they were being rendered? Defendant's counsel objected to as being incompetent, irrelevant, and immaterial. Did you approve it orally? Defendant's counsel objected to as being incompetent, irrelevant, and immaterial, trying to vary the terms of a written agreement. Plaintiff's counsel, your objection, counsel, is not well taken because we are not attempting to vary the instrument at all, but merely to ascertain whether there was approval orally rather than in writing. Defendant's counsel, it is immaterial whether he approves it. If it is a corporate charge, then the plaintiff should look to the corporation for payment. If these services were rendered at the special instance and request of the defendant Parnell for himself, he certainly is liable for it. If it was rendered for the corporation, even if he did approve it, which we don't admit, then the corporation is liable for it. He assumed no personal obligation, and there is no assertion that he assumed a personal obligation in contracting for the corporation. Plaintiff's counsel, there is no objection then to that last question, whether or not it was approved orally. Well, according to this agreement that you entered into with the corporation, Mr. Parnell, you agreed to pay all the cost of labor and selling commissions and overhead and all the other items of expense. Plaintiff's counsel, is that the question? Defendant's counsel, objected to on the ground that the writing speaks for itself. Paragraph 1 of the agreement states that Parnell shall have the sole right to order the manufacture of said products to be made and agrees to furnish forthwith the funds necessary to provide all labor and material in the manufacture, sale, and distribution of said product. Now, it is a fact, is it not, that the services rendered by Mr. Kranz were necessary to enable you to manufacture and sell the Save More banks? Defendant's counsel objected to as being immaterial and irrelevant. Plaintiff's counsel, under the Common Count Counsel, Defendant's counsel, you had your opportunity to allege that these services were rendered to Parnell, and you are precluded by the bill of particulars and the proof that can be offered, counsel. Plaintiff's counsel, there can be fraud too, in that the corporate entity could be interposed now as a defense, whereas actually it was nothing more than a shell. And if that is the case, it is one of the issues of the common count. Defendant's counsel, counsel has not so alleged, and you are precluded in your proof to what was set forth in your bill of particulars. Were you personally active in the management of the Save More Corp company? Yes, I was. Who else was active in the company? Only myself. Was Mr. Melvin Stone associated with you in this business? Yes, he was, to a limited extent. In what capacity? He sold banks on one of his trips to Chicago, and I believe within a limited scope, he sold a few dozen banks in Long Beach. Did you order the manufacture of banks by anyone other than Harco? No, I did not.
Too fast.
Too fast? It was,
What is this?
$185. Are you getting any objections? I write incompetent, irrelevant, immaterial. By this time, you should have a one-stroke outline for that stuff.
Well, it only, but I am, that's the main one, incompetent. I was writing I am, because I thought that's what you told me to do, but that's I am. I am as I am.
I write them all twice. I am twice. Irrelevant.
I thought
I
you
are
just
twice.
said the sentence before this, you should have a one-stroke outline for.
Well, to me, that's one stroke. Because it's so fast. When you write the same outline and it's just a couple of letters, it's fast. I mean, you can't get any faster than that. The one stroke outline might be the same stroke. I mean, it might be, I don't think it would be fast. Because you're not thinking about it. See, when you're writing it, you're thinking about what's coming afterwards. You don't have to think about the two-stroke for I. So immaterial, I write I am twice in objections, and irrelevant, I write I are twice. You don't have to, but I do it just to be sure. Okay. But that's a big objection thing. Then, of course, you haven't been in court, so you're not used to it, but for instance, I have a short form for bill of particulars. The lawyers will always say, well, it's in the bill of particulars, bill of particulars, bill of particulars, it's like one word. All right, Bix. But if you haven't been in court, there's no point in you're not going to learn it. You're not going to get it very often. Okay. See, that's why when Dan failed the lower court test, he said that the testimony was fine and couldn't get the colloquy. If you had taken it, of course you didn't take any colloquy. If you had taken a lot of colloquy, you'd be used to it. Ready for another take?
No, wait.
Huh?
No, hold on one second. second, I'm looking over the notes, I didn't get it at all.
Do what?
I really didn't get that one.
Alright. I'll give you another one.